Ma'am, step out of the vehicle. Your plates match the federal alert.
My plates match nothing. You have no cause
I said
to stop
step out now.
You haven't answered my question. What alert?
That's not your concern. Hands where I can see them.
I am 8 months
You are being
old.
detained.
The blue lights came without warning. One moment, the Texas highway was empty and quiet, the last light of evening bleeding into the horizon. The next, a set of red and blue strobes filled every mirror in her car, and the world she had spent over a decade building was about to collide violently with the one she had spent that same decade keeping in order. She pulled over. She had no reason not to. She had done nothing wrong. That, as it turned out, would not matter. Before the story goes any further, drop a comment right now and let us know where in the world you are watching from. If you have ever seen someone in a position of power abuse it and walk away without consequence, stay with this, because what unfolds over the next few minutes is the rare story where they did not. Hit that like button, subscribe if you have not already, and let us get into it because this one earns every second of your time. The pull to the shoulder happened gradually, the kind of controlled deceleration that suggested neither guilt nor panic. Only the practiced calm of someone who had learned long ago to move deliberately under pressure. Gravel shifted under the tires as the car eased off the asphalt. The engine idled. The blue and red lights swept across the windshield in slow, rhythmic pulses, painting the dusty roadside in alternating color. It was 6:48 in the evening on a stretch of state highway outside Houston, Texas. The sky had not yet gone fully dark. It hung in that suspended moment between gold and gray, the sun already below the tree line, but its light still clinging to the underside of the clouds like something reluctant to leave. Inside the car, a woman sat with both hands resting on the steering wheel, waiting. Her name was Anna Barrett. She was 39 years old, 8 months pregnant, and dressed as she had been since 7 that morning, a dark blazer over a fitted maternity top, her hair pulled back with the kind of efficiency that comes not from vanity but from habit. A leather folder of case files occupied the passenger seat beside her. Her reading glasses were folded on top of it. On the back seat, a cardigan she had stopped wearing 2 hours into the afternoon because the courthouse's central heating had been running too high. She had spent the day in federal court. Not as a witness, not as an attorney. As the judge, for 11 years, Anna Barrett had presided over a federal docket in the Southern District of Texas, a courtroom where careers had been made and ended, where constitutional arguments had been tested against the weight of real consequence, and where her name had become synonymous with one particular quality above all others: precision. She did not rule carelessly. She did not speak carelessly, and she did not, under any circumstances, mistake the performance of authority for the possession of it. She had seen too many people confuse the two. She was about to see it again. The vehicle that had pulled her over was unmarked, a dark SUV with government plates, but no agency markings visible from the outside. There was no second vehicle, no radio communication audible from where she sat. The figure that emerged and approached her driver's side window did so with the particular stride of someone who had rehearsed this moment more than they had studied the law governing it. He was a large man, broad through the shoulders, wearing a tactical vest over civilian clothing. His badge, the detail Anna noticed first, was not holstered or mounted cleanly. It was clipped to the front of his vest at a slight angle, the way someone clips a badge when they are thinking more about being seen than about being official. He introduced himself, when he reached her window, as ICE Agent Peter Dawson. He told her that her vehicle matched a federal alert. Anna said nothing immediately. She understood, with the clarity that comes from years of hearing arguments constructed on weak foundations, that something was wrong with that statement before he had finished making it. There had been no visible plate confirmation when he had pulled in behind her. No radio check. No backup unit waiting at a distance. No documentation in his hands. Every standard protocol that preceded a legitimate vehicle stop appeared to be absent, and in their place was a man who had decided, for reasons not yet disclosed, that she was someone he needed to stop. She asked him, calmly and without agitation, to identify the specific nature of the alert. He did not answer the question. Instead, he asked where she had come from. He asked where she was going. He noted, with a studied neutrality of someone who had rehearsed this particular phrasing, that she appeared nervous. She was not nervous. She was evaluating. There is a particular kind of restraint that develops in people who spend years in courtrooms, a discipline of response, a trained understanding that the moment you allow your reaction to overtake your reasoning, you have already ceded ground you may not be able to recover. Anna had that restraint in abundance, and she deployed it now the way she always had, quietly, without announcement, with complete control. She informed Dawson that she would comply with any lawful instruction he issued. She also informed him, with equal composure, that she would not consent to a detention that lacked legal basis. The shift in his manner was immediate. His posture changed. His tone hardened. The careful rehearsal dropped away and something more blunt took its place, not rage, but the specific irritation of a man who had not expected resistance and did not know what to do with it. He told her to exit the vehicle. Anna did not move immediately. Not from fear. Fear was not what was happening behind her eyes in that moment. What was happening was calculation. The same calculation she applied when an attorney before her attempted to assert a legal position without supporting it. She was watching, she was noting, and she was already 3 steps ahead of where the exchange appeared to be. With her right hand resting on her stomach, she reached her left hand toward the center console. The motion was small and unhurried. She pressed a single icon on her phone screen without looking down at it. The recording had begun. Every word spoken on that roadside from that moment forward would be preserved not as allegation, not as memory, not as one account competing against another, but as evidence. Dawson did not wait. He stepped to the door of her vehicle, gripped the handle, and pulled it open. He told her to step out immediately or he would remove her himself. Anna stepped out. She moved with deliberate slowness, one hand still resting on her stomach, her feet finding the gravel shoulder with care. The evening air was cooler than the car had been, the sharp, clean chill of a Texas November cutting through the blazer she had worn for warmth that morning. She stood at the roadside, visibly 8 months along, facing a man twice her width who had stopped her without cause and was demanding compliance without law. She told him she was pregnant. She told him, in the same steady register she used in her courtroom when correcting an attorney who had cited case law incorrectly, that he was violating federal statute. Dawson did not acknowledge either statement. He placed her in restraints. The narrator does not linger on this moment because it was dramatic, it lingers because of what it meant. The woman now standing in hand, restraints on the shoulder of a Texas highway, cars moving past at speed in the gathering dark, was the same woman who had written the rulings in more than 24 federal cases that established the legal framework for identifying and remedying exactly this kind of unlawful detention. She had not simply studied the constitutional protections Dawson had just violated. She had, in many meaningful ways, helped define them. He had no way of knowing that. And his ignorance, from the moment those restraints closed around her wrists, was already the beginning of his end. Anna stopped arguing. There was nothing more to say that would change what was happening in the next 60 seconds, and she understood that better than most. She watched Dawson move around the vehicle, checking the plates now. Finally, after the stop had already been made, the sequence entirely reversed from how a legal stop is conducted. She watched him the way she watched attorneys who had overcommitted to a losing position, with a kind of patient, almost clinical attention that contained no anger, because anger was unnecessary. The recording ran silently in her coat pocket. Headlights swept past on the highway, drivers who slowed for a moment, registered the scene of a government vehicle and a woman standing on the shoulder, and continued on their way, carrying no idea of what they had just passed. By morning, they would know her name. By the end of the week, so would the country. She drove the remaining miles home without the radio on. The highway thinned as she moved further from the point where Dawson had pulled her over, the landscape shifting from open road to suburban streetlight, the familiar geometry of her neighborhood eventually replacing the flat, featureless dark of the interstate. She had been released after less than 20 minutes, Dawson finding nothing, documenting nothing, offering no explanation for the stop beyond the vague alert he had never been able to specify. He had uncuffed her with the same disinterest with which he had cuffed her, returned to his vehicle, and driven away as though the encounter had been entirely unremarkable. The recording had run for the entirety of it. Anna did not stop it until she pulled into her driveway, cut the engine, and sat for a moment in the silence of her own garage. Then she pressed stop, locked the file, and went inside. She did not call the police. There was a reason for that, not avoidance, but precision. A complaint filed with local law enforcement against a federal agent required a specific pathway to be effective, and Anna knew that pathway better than the people who were supposed to walk it. What she needed was not a report. What she needed was someone who understood how to move evidence through federal channels without triggering the kind of institutional defensiveness that caused investigations to stall before they started. She called Reeves. Daniel Reeves had clerked for Anna during his final year of law school, a decade earlier. He had been, in her estimation, one of the most methodical legal minds she had encountered in 20 years on and around the bench, unhurried, precise, constitutionally allergic to shortcuts. He had gone on to build a civil rights practice in Washington that had produced several significant federal settlements, and more relevantly, he had spent the last 3 years cultivating working relationships inside the Department of Justice's Civil Rights Division that most attorneys spent entire careers trying to establish. He answered on the second ring. Within the hour, the recording had been transferred through encrypted channels to Reeves's office. He reviewed it himself before forwarding it with a formal legal memorandum to 2 specific contacts within the DOJ, not as a tip, not as a complaint, but as documented evidence of a potential federal civil rights violation submitted by counsel, with a preservation request attached. By midnight, the footage was being reviewed at a level of the department that Peter Dawson had likely never needed to think about before. What the investigators found when they began pulling Dawson's field records was not a surprise to Anna, though it was to the people pulling the files. The stop on the highway had not been an anomaly. Over the preceding 14 months, Dawson had conducted 31 documented vehicle and pedestrian stops under the same loosely worded justification, a vehicle or individual matching a federal alert. Of those 31 stops, not one had resulted in a charge. Not one had produced a formal arrest that moved to prosecution. And a significant number of them, the investigators would later determine, it was more than half lacked the minimum documentation required under ICE field protocol to justify an enforcement contact in the first place. Anna had not been his first unlawful stop. She had been his 32nd. The difference was not the nature of what he had done, it was the nature of who he had done it to, and what that person knew how to do in response. Preservation orders went out within 48 hours of Reeves' submission. Internal communications were subpoenaed from the relevant ICE field office. What those communications contained, when investigators began working through them, reframed the entire picture. Buried inside message threads between agents and their supervisors was the architecture of something that had never been formally written down, but had been consistently practiced. An unofficial performance framework that measured agent productivity not by the quality or legality of enforcement actions, but by volume, stops, contacts, detentions. The language used in the messages was careful, nothing that named the system explicitly, but the pattern was unmistakable to anyone trained to read institutional communication, which the DOJ investigators very much were. The goal had never been enforcement in any meaningful sense of the word. It had been numbers, metrics, The appearance of activity in field reports that made their way up chains of command to people who asked only whether the numbers were trending in the right direction. Behind every number was a person. The investigators began to understand this as the picture expanded individuals who had been stopped, detained briefly, and released without charge or explanation, their names logged in field reports as contacts and nothing more. Families who had spent terrifying hours waiting for someone who had been detained without cause. People who had not known their rights, or had known them and been ignored, and who had no equivalent of Anna Barrett's recorded evidence or Daniel Reeves' federal contacts to translate their experience into consequence. More of them came forward as the investigation widened. Some had attempted to file complaints before and had been turned away or ignored. Some had assumed, as people often do when institutions close ranks around themselves, that nothing would come of it regardless. But the nature of federal investigations, once properly initiated, is that they create gravity, and gravity, once sufficient, draws things toward it that would otherwise have stayed still. Dawson, through all of this, remained unaware of the full shape of what was unfolding. He had returned to work the morning after the stop and continued his routine in the weeks that followed with the particular ease of a man who had done this before and never faced a consequence. He had written his field report on the Anna Barrett stop in the same vague, template-adjacent language he used for all the others. He had moved on. At this point in the story, it is worth pausing because what happened next divided opinion sharply among people who followed the case closely. Do you think a judge who was personally wronged should have any role in the proceedings that follow, even indirectly? Type yes or no in the comments. And if you have ever watched someone in authority cross a clear line and simply walk away from it, share this video because the reason most stories like this one end differently is that no one was recording and no one with the right connections picked up the phone. 3 days after the highway stop, Dawson received a standard court appearance notice. It named a case number and a date in a courtroom in the federal building in Houston. It asked him to present as a witness in what the notice described as a routine immigration enforcement matter. He had testified in proceedings like this before. It was administrative. It was familiar. He reviewed his notes the morning of the appearance, adjusted his tie in the mirror of the men's room near the courthouse entrance, and walked in carrying the straightforward confidence of a man who had no reason to believe the next hour would be anything other than procedural. He took his place. He settled into the posture of someone prepared to give testimony, organized, measured, ready. The courtroom doors opened from the rear. The sound they made, that particular weight of federal courtroom doors swinging on their hinges, was a sound Dawson had heard dozens of times. He did not look up immediately. He was reviewing a line in his notes. By the time he raised his eyes toward the bench, the figure had already moved to the front of the room. The recognition did not arrive cleanly. It came in pieces, the posture first, then the way she moved, then the set of her jaw as she settled into the chair above him. His mind ran the comparison against memory and slowed, the way a system slows when it encounters something it cannot immediately reconcile. The woman from the highway had been on a roadside in the dark. This woman was in robes, behind a federal bench, in a room where every surface and every arrangement of furniture communicated, without ambiguity, where the power in this building resided. They were the same woman. The room had gone quiet in the way that federal courtrooms go quiet, not the absence of sound exactly, but the presence of a particular kind of attention. Every person in the gallery and at the counsel tables oriented toward the same point without having been asked to be. Judge Anna Barrett stated his name. Her voice carried no edge and required none. The acoustics of the room did the work of amplification, and the content of the moment did the work of weight. She instructed him to remain standing. Dawson stood. The notes he had been reviewing were still in his hands. He did not look at them again. The press would later reach for superlatives to describe what Anna did next. They would use words like devastating and surgical and unprecedented. What she actually did was considerably simpler than any of those words implied. She followed the law, completely. Without deviation or embellishment, before the morning session concluded, she had issued 3 directives from the bench. The first ordered the immediate preservation of all materials connected to the enforcement stop conducted on the evening in question, the field report, the vehicle logs, any communication referencing the stop before or after it occurred. The second formally referred the incident to the Department of Justice Office of Professional Responsibility for Independent Federal Review, citing the specific statutory provisions under which the referral was being made and the specific conduct that triggered them. The third was her recusal, voluntary, immediate, and complete, from any proceeding in which Dawson was a named party or material witness. She did not wait to be asked. She did not negotiate the scope of the recusal or limit it in ways that might have preserved some residual involvement. She removed herself entirely, documented her reasons in formal language that left no interpretive room, and filed the recusal with the court administrator before noon. The legal community that followed the case understood immediately what this meant, even if the wider public took longer to grasp it. By recusing herself before any ruling touching Dawson's conduct had been issued from her courtroom, Anna had foreclosed the single most viable avenue of defense available to him. There was no longer any argument to be made that the outcome of the investigation had been shaped by personal grievance, no claim of judicial bias that could attach to the proceedings, no procedural angle through which his attorneys could introduce the contamination of motive. She had handed the case to an independent structure and walked away from it, and in doing so, she had made the evidence the only thing that mattered. That evidence was considerable. The recording was entered into the federal record and played, in full, during the DOJ review proceedings. Investigators described watching it in the same clinical terms they used for all evidentiary review, but the people in the gallery who observed those sessions noted the particular quality of attention the footage commanded, the way the room contracted slightly when Dawson's voice came through the speakers, and the way it contracted further when the image of Anna, 8 months pregnant and standing in restraints on a highway shoulder, filled the screen at the front of the room. Dawson's legal team argued that the stop had been procedurally justified, that the federal alert designation, however imprecisely documented, provided a legitimate basis for the contact. Federal investigators responded to this argument with the product of their expanded inquiry. 31 stops, 14 months, 0 resulting charges. Documentation inadequate in more than half the cases reviewed. Dawson's attorney had come prepared to defend a single decision. The investigators had come prepared to document a practice. The internal communications made the practice impossible to characterize as coincidence. When the message threads were authenticated and their contents entered into the record, the supervisor-level agents who had authored and forwarded the quota directives became subjects of the investigation in their own right. The language in those messages had been careful its authors had understood, at least in the abstract, that direct instruction to conduct unlawful detentions would not survive scrutiny. But the cumulative meaning of what they had written was not ambiguous to investigators trained in reading institutional communication, and it was not ambiguous to the federal attorneys who translated that reading into charges. The indictments came sequentially. Dawson's arrived first, carrying charges of unlawful detention and federal civil rights violations. 3 supervisory agents followed within the same week, their charges shaped by their level of documented involvement in the directives, ranging from conspiracy to deprive civil rights to obstruction of the subsequent investigation, which 2 of them had attempted in ways that proved, ultimately, only to deepen their exposure. The careers collapsed quickly, in the manner of things that were already structurally compromised before the pressure arrived. People who had been building professional identities inside the same enforcement framework for years found that the framework itself had become the subject of federal scrutiny, and that proximity to it was now a liability rather than a credential. Entire divisions of the relevant ICE field office were placed under federal oversight pending restructuring. The supervision chains were redrawn. The documentation protocols were overhauled under mandated timelines. Dawson refused to cooperate with investigators throughout. He maintained, consistently and without apparent doubt, that his actions on the highway had been lawful, appropriate, and consistent with his training, a position that his attorneys continued to advance as the evidence against him accumulated, and that he appeared to hold with a certainty that the investigators found, by the time of trial, remarkable in its persistence. His trial was not long. The prosecution's case rested principally on the recording, the field record pattern, and the authenticated internal communications. Dawson's defense rested principally on his account of the stop and the argument that the alert designation had provided sufficient legal basis for the contact. The prosecution played the recording in open court on the second day. The gallery, which had been moderately attentive through the preceding testimony, went very still. What the footage showed was not complicated. It showed a man who had stopped a vehicle without visible cause, deflected a direct question about the basis for the stop, conducted an interrogation without legal foundation, opened a car door without consent, and placed hand restraints on a visibly pregnant woman after she had identified herself and invoked her rights, all without producing a single piece of documentation that would have justified any step in the sequence. It showed these things not as allegation, not as reconstruction, but as they had occurred, in real time, in the voice and image of the people who had been present. The jury deliberated for 11 hours across parts of 2 days. The verdict was guilty on all counts. Sentencing came 6 weeks later. Dawson received a federal custodial sentence. His supervising agents, whose culpability had been assessed individually based on their documented roles in the quota framework, received terms that ranged from substantial fines and probation to multi-year custodial sentences for the two most directly implicated. The sentencing judge, in remarks delivered before the formal pronouncement, noted that the harm documented in the case extended well beyond the individual who had initiated the investigation, that the 31 stops represented 31 separate failures of the constitutional framework that enforcement agencies exist to uphold, and that the sentences being imposed reflected not one event, but a sustained practice. Anna was not in the courtroom for sentencing. She was in her own courtroom, several floors and a building away, hearing arguments in an entirely unrelated matter. She had made no public statement at any point during the proceedings, no interview, no press release, no comment relayed through counsel. When sentencing was reported by the Houston media that evening, her name appeared in the coverage as the inciting incident and nothing more, which was precisely how she had structured her involvement from the moment she pressed stop on the recording in her driveway. She returned to her full docket the following week. Her law clerk noted, in a recollection shared months later, that she had come in that Monday carrying the same leather folder that had been on her passenger seat the evening of the stop, sat down at her bench at the appointed time, and proceeded through the morning's motions with the same methodical attention she brought to every session. Nothing in her manner indicated that the week's proceeding had been anything other than routine. What the case left behind was not routine. New field documentation requirements, applicable across multiple ICE operational regions, came into effect within 4 months of sentencing. Mandatory supervisory sign-off for stops lacking initial charge documentation became federal policy. An oversight framework, modeled in part on the findings of the DOJ review, was implemented across 3 field offices, with annual reporting requirements that would remain in place indefinitely. Civil rights attorneys around the country cited the case in subsequent litigation as establishing a practical accountability standard for enforcement contact that the existing case law had left underspecified. None of this had been Anna's stated goal. She had filed a recording through proper channels, referred a matter for review, and removed herself from the proceedings. The outcomes that followed were the product of what the evidence contained, not of any orchestration on her part. That, in the end, was the point. The misconduct that Peter Dawson had engaged in on a Texas highway was not rare. Investigators said as much, carefully and on the record, when the case concluded. What was rare was the combination of circumstances that had surrounded it. A subject who knew exactly what she was witnessing, who responded not with emotion but with method, and who understood that the most powerful thing she could do in the moment was not to argue, not to resist, but to document and to wait. Dawson had made his calculation on a dark highway in the certainty that the woman in front of him had no recourse that would reach him. He had been wrong in the most consequential way. A person in his position could be wrong not because of what he had done, but because of who had been watching, and because of everything she already knew about what to do next.
If you like this video, make sure to hit that like button, subscribe, and turn on the notification bell so you don't miss the next story. Share this video with someone who would appreciate it, and let's keep building this community together. And before you go, drop a comment below. I'd love to hear your thoughts on what stood out to you the most. Until next time, stay safe, stay curious, and I'll see you in the next.